continue with our conversation about presentment, especially since 4 of the people that were named in the BOCC meeting are here.
Can you speak a little bit more into the mic, please?
The last comment that Ken Evers and myself had was that he was saying that the order to repress was the judge's order to release the document. I'd like to know the 4 people that were named, who had knowledge of the repression paper before midnight, March the 6th.
Do you have a follow-up to that? Because
I've got 2 or 3.
okay, let's go ahead and line them up, and then we'll ask Mr. Evers to respond to that.
The state filed on February the 9th that all repression proceedings be sealed. All documents regarding the proceedings be sealed. The only thing that was allowed to be released was the presentment itself to the people that were named in the presentment. I would like to know which one of the 4 had knowledge of that document on midnight of the 6th prior to it being released. And the state released it on the 10th of March. Not on the 9th. They made a special filing to release the repression hearings that were filed under seal on the 10th of March. And I'd like some answers.
Mr. Evers, would you like to address that?
Sure. Don, I clearly had knowledge of all of the repression proceedings because I was involved. I filed 2 separate motions. I attended the hearings. Mrs. Hernandez, as the chairman of the board, was present for one of those hearings. The hearing that resulted in the order that you keep bringing up, the hearing that talks about, that resulted in an order saying that the presentment becomes public basically at the end of the appeals period on March 6th. The hearing that generated that order, Vanessa was present with me.
Okay. And that meeting was on what date? February the 4th, ring a bell?
Possibly.
Okay. Were you in his chambers and Miss Vanessa Hernandez in his chambers on the 6th when he signed the order?
No.
Then how are you privy to this information?
How am I privy to what information? I saw the order. The order was served on me.
We were the last to file, and the document states we were the last to file any protest to the release of the presentment. We did that on the last possible day that you could file that motion. We were made aware, and I believe that it's even stated in the document, that the order that denied the motion, that should we protest that, then it would go to an appellate court, and should we not protest that, that it would be released in a certain number of days. I believe that was 30. Do you recall, Ken? I don't have that document in front of me, but
The order read that the presentment, and it identified it by date, became a matter of public record at the expiration of the appeals period within which the IDA could appeal on March 6th.
And Ken and I were the only individuals that could have initiated the appeals process.
Okay, so y'all two are the only ones that had knowledge of this document. Which one of you 2 told stand-up party it was okay to release it?
I didn't have any communication with the stand-up party, but if you want to know, when Bill Lambert asked me, when does this document become public, I answered.
And I emailed my normal email list, Don. I presume that's how they got a hold of it.
I had no communication. I had no communication with.
So you're communicating with the public over the internet.
Yeah, I do that all the time. I have an email list. If you'd like to be on that list, call the office and we'll place you on the list.
No.
It was the- It was, we were the only ones that could have protested it. We did not, we knew we did not by the end of the business day on March the 6th. Therefore, at the end of the business day, when you can no longer file anything to appeal the process, then the document is public.
So when it says it's sealed, that's still communications, right?
It says what sealed?
The repression proceedings were sealed by the state on the 9th, was not released until the 10th. You were served.
The parties who had copies knew what was going on, Ron. I mean, I got a copy of that order that said I didn't have to wait on the state. In fact, I have an email, me and the state back and forth on Friday the 6th, where I confirmed we shared agreement on what the law was about when that thing became public.
Okay. Under the state's filing of the motion, it does say the presentment remains sealed until the expiration of the appellate time. The order did not specify that the court repression proceedings also were subject to the public record. The state has received a request from a citizen for copies of documents related to the repression proceedings. According to the state, now moves the court for authority to release the documents. And under number 4, it says, counsel for the IDA, Mr. Kenneth Evers, Esquire, has been contacted and on behalf of his client does not object.
That's correct.
On the 10th.
That's correct. And there's an exchange of emails, Don, between Victoria Avalon and myself, where we agreed that the repression proceedings, once the presentment itself, we agreed in the emails that as a matter of law, that once the presentment became public at midnight on the 6th, that the repression proceedings also became public. I have the email from Victoria Avalon. I understand. She says, so on Monday the 9th, I get an email and she says, Mr. Evers, we're going to file a motion. Not that it's necessary, because we believe that under current law, the repression proceedings are public. But we would like an order, because we have a public records request from somebody for these records. And so they wanted it to be clear, but the emails between us were clear that we were in agreement that Florida law says that the repression proceedings became public the same time the presentment did. I told her, your motion is not necessary because we're in agreement about when it became public. And she says, well, I'm going to file it anyway. I said, okay.
And you have those emails?
I do. And I'll be glad to give a copy.
Thank you.
Any further public comment?